Hi, everybody. Welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers, and for today's episode 126, we're going to get into some new subject matter. I'm going to start looking at good estate planning drafting. Now, notice I'm saying good and not better or best. Really, what I'm trying to do is hit the top of the bell curve in terms of what estate planning attorneys and wealth advisors and even clients should look for. And we're going to start today with the family statement. Now, before I dive into the subject matter, what I really want to say is drafting is one of my favorite parts of estate planning. This is why I do what I do, because I love the custom drafting part. To me, it's like programming almost, that you're fitting different pieces of the puzzle together and creating consistency and flow, and there's all sorts of creative aspects to it that I really enjoy and that keep me doing what I do. And really, I want to share that passion with you in this good estate plan drafting series. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, as I mentioned, today we're going to focus on one aspect of wills and trusts, and that's that they typically include a statement of family. That's because it's universally a good idea to identify the family members in wills and trusts that'll be beneficiaries or fiduciaries under that instrument, because if you leave that blank, the law reads into certain definitions that can make your family broader or more narrow than what you intend. Now, a lot of forms have language for statements of family, even if you have document assembly software, but there are nuances to that, and you have to know the nuances, one, to be able to make the right choices, or two, to be able to go back and custom edit language after the fact. So when it comes to the statement of family itself, typically you're going to have individual family members identified in two ways, and both of these could be present or absent depending on how you want to draft it. But one, commonly you'd include people by class or by family affinity, such as spouse or children or descendants, and that could refer to any number of individuals over time depending on when the instrument is signed and when the instrument takes effect. You can also refer people just simply by name and without reference to class, whether or not they're related by blood, and still treat them as if they are family members. Now, another issue is whether or not you can change the statement of family after the fact. Obviously, when you do an instrument, I like to say that you should base it on today's expectations, but also future expectations, because if you intend on changing it every time there's a change, the chances are you don't get around to making that change, and the document or instrument is not going to work how you intended. So, that being said, a lot of things like a will or a revocable trust can actually be changed over time, but you also have irrevocable trusts. And while in the past those couldn't be changed, it's important to note that nowadays they can be modified or decanted, but it's not necessarily good to rely on that. You need to make the statement of family as broad as is needed to capture your intent, because changing a family member's interest in a trust after the fact, even if it's permitted by law under a modification or decanting, it may cause adverse tax or legal consequences. And sometimes you can't even modify or decant in a way that would deprive a family member of their trust interest or shrink that interest. So, if you want to change this in the future, it's good not to rely on the ability to make a future change. You want to make this as flexible as you possibly can. Now, we're really going to look at those three categories of family member I mentioned: spouse, children, and descendants, and look at how we identify those. And we're going to start with a spouse. Now, there's lots of issues that can arise here, and this is kind of top of the bell curve, but some of the factors are: one, is the spouse who you identify in the instrument actually married to you at the time that you execute the will or trust? If not, you need to draft around that and say, hey, it's my intent to marry this person in the future, but right now we're not. Otherwise, that can cause all sorts of issues and all sorts of conflicts, especially if the two of you never get married, and it could create an incentive to try to go back and claim a common law marriage after the fact by the surviving spouse or partner as well. Another issue is what happens if you get divorced. Typically, a lot of states' laws will say when a divorce is finalized, maybe the spouse or partner or whoever will cease to be an interested party under that instrument at the time that the divorce is finalized or at the time that the relationship terminates. But that's not always the case. Sometimes if you change the will after a divorce is in process, the spouse will still inherit under it, or even if you never get around to changing it, some states don't terminate a spouse's interest in a will or trust by virtue of divorce. So if you die between filing for divorce and when the divorce is final, that's one area that should be addressed. And if you die after the divorce is final, what should happen to the spouse's interest? That should be addressed as well, so your intent is not muddied. And even if the state law does allow for termination of an interest upon divorce, you might move, you and your spouse might move, and that may no longer be the case in the future. So that needs to be drafted in for maximum flexibility. Another issue is what happens if you've previously been married? If you have a new spouse later added to the instrument, what potential for conflict might exist between the new spouse and between children or descendants, whether of a prior marriage or the current marriage or whatever the case might be? Now, there's all sorts of ways you can look at that, and one recent concept that's been baked into a lot of irrevocable trusts is the concept of a floating spouse, in that the definition of spouse just refers to whoever you might be married to at the time, and that could raise all sorts of conflict too, so you need to address that. And then finally, when it comes to any external agreements that can affect the flow of your estate plan, things like prenuptial agreements, it may be a good idea to incorporate them by reference into that statement of family, just so any fiduciaries know what to look for in terms of how your estate should be distributed and what claims there might be against your estate prior to distribution. Next, we get into identification of children. Now, in most cases, this is generally straightforward because your children are your children, but there are some issues that come to mind. One, should you include the birth date of your children? That's generally a good idea to include a birth date, at least for minor children, so you can know who's a minor and who needs to have a guardian appointed and so on and so forth. But it may also be a good idea for adult children as well. There's a few reasons. One, if retirement plan assets are payable to children, you may need to determine their life expectancy, especially if they're eligible designated beneficiaries. And two, if you include a certain age, maybe where a child becomes a trustee of a trust, then you need to be able to identify at which point they reach that age. So birth dates are generally a good idea, especially if age milestones are indicated within the instrument itself. Another question that comes up is, should you include subsequently born or legally adopted children in the reference to children? So it kind of depends on the age of the client. And one issue that often comes up is, obviously after a certain age, it's more difficult to have children, and it's more difficult to have a child come out of nowhere. So you need to kind of draft around, what if there's an unknown child out there? You want to kind of limit that definition and just say it's these children plus any subsequently born to or legally adopted by me, if you want to omit any prior born children that are mysteries. You also need to keep in mind too that adult adoption is a thing, and it's something that can be used for fraudulent purposes, where maybe an adult befriends an elderly person and convinces the elderly person to adopt them for purposes of inclusion in the estate. And if that happens, then that should be cut off as well, maybe in the statement of family, but more often in a separate provision that defines adoption and when it is actually valid. We'll look at that a little bit more when we talk about descendants, but another issue I often see come up is, if you're remarried, should your spouse's children also be included or expressly omitted? Now, children-in-law or stepchildren never have a right under law to inherit from your estate, but you may want to expand that, but you may want to emphasize that you want that law relied upon. So either way, you need to kind of make sure that that's clear in the statement of family. And then finally, if any children are disinherited, it may be a good idea to identify who they are and state that it's intentional that you've omitted them or disinherited them. Otherwise, a lot of states have laws that say accidentally omitted children can still benefit, maybe by getting their intestate share under a will or trust instrument. Then finally, when it comes to descendants, some of these issues come up with children as well, but generally the terms descendants and issue are going to be interchangeable state to state and are generally going to include your children and any offspring by birth down the road. So, as I mentioned with children, should adoption be included? So your children might adopt in the future. To what extent do you want their adopted children to be included in your estate plan? There's all sorts of issues that can come into play here as well with your genetic material. If it's preserved, what if you have children after your death? Do they become beneficiaries under the plan? Or if you've engaged in sperm or egg donation, those are becoming less private and more public. And could a child through donation who's been anonymous all of a sudden discover that your estate is there for their claim and try to make a claim against your estate even though you didn't know about them? So with that, how broad or how narrow should the class of descendants be? And some of that relates into your children as well. And finally, if a child is omitted or disinherited, should their descendants also be similarly omitted or disinherited? It might be a good idea just because the omitted child could steal from them down the road, but it may not be a good idea depending on if you have a good relationship with them and you want to provide for them. And it's important to note that all these provisions, but especially this omission or disinheritance piece, can carry over into other provisions of the will or trust instrument, things like the remote contingent disposition clause that might refer to descendants by state law, and you may want to make sure that omitted children are also omitted there, or omitted descendants are omitted there as well. Another one that comes to mind is a no contest or an interorum clause, where you say if anybody challenges the will, they forfeit their share. And this concept of disinheritance can relate into that, but that is a subject for another time. So if you're interested in seeing more on drafting, what I plan to do is cover this more in future episodes. I've covered a lot on tax, and I'm going to shift more into drafting issues just because it's a part of estate planning that I enjoy. I also plan to have maybe a blog in the future, part of which will be dedicated to drafting, maybe with sample language, because a lot of this doesn't translate well to video. It's important to have it in written form too. And the videos and the articles will really serve as a guide to the use of sample language. But with that, anytime you provide sample language as an attorney, you have to restrict use so you don't get sued. So because of that, if I provide sample language in the future, I'll probably require a subscription or some sort of registered and limited access, just because I don't want random people to just take my language and then misuse it and then come back and sue me just because they didn't fully grasp how things are supposed to be used, even in the video or guidance that I provide. So that's something coming down the pike, but be on the lookout for it. In the meantime, for at least the immediate future, I will continue this drafting series. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.